Good morning, everyone. Thank you for joining us for our probably third workshop related to notices. I know when we first began reviewing our regulations, of course, our notices are mentioned currently in the Commission's regulations, the 800 series. And then we recently had another follow-up meeting at least a month ago, and then today's follow-up meeting. And staff filed a draft proposal in docket 2020-247A. We appreciate everyone's comments who participated in letting us know your thoughts regarding the draft, second official draft, it could be the third, for amending, modifying our public notices related to commission events. So I'm going to start first today for the sake of our court reporter, our diligent court reporter, Ms. Jo Wheat, to ask who's here on behalf of the entities that filed, comments, and then we'll proceed. So I'm Jocelyn Boyd. I'm the Chief Clerk at the Public Service Commission. May I ask who's present on behalf of Lockhart Power Company?
Good morning, Jocelyn. This is Peg Fox. I am here along with David Turner, the company's business controller, on behalf of Lockhart Power.
Good morning, Ms. Fox. Good morning, Mr. Turner.
Good morning. How are you?
I'm doing well. I hope you are.
Doing fine, thank you.
Good, good. Piedmont Natural Gas Company.
Good morning. My name is Jason Richardson. I am here on behalf of Piedmont Natural Gas Company. I appreciate it.
Thank you. Nice seeing you for the second time. I think the third time in probably the last month and a half, Mr. Richardson, in this hearing room, of course. Duke Energy Carolinas, LLC, and Duke Energy Progress, LLC.
Good morning. My name's Lyle Trawick, and I'm here on behalf of the Duke companies.
Good morning, Mr. Trawick. Good to see you. As everybody can see, we have some people who are present in the hearing room. We appreciate that. We appreciate those who are appearing virtually also. The Office of Regulatory Staff.
Good morning, Ms. Boyd. This is Chris Huber here for ORS.
Good morning, General Counsel Huber. Department of Consumer Affairs.
Hi, good morning, Jocelyn. Roger Hall for the department.
Good morning. I think you're a Deputy Consumer Advocate, aren't you, Mr. Hall?
Yes, I am.
Yes, good morning. And Blue Granite.
Good morning, Ms. Boyd.
morning.
Frank Ellerby for Blue Granite, and with me is Zach Payne, financial analyst for the company.
Awesome.
Thank
Good
you.
morning, Attorney Ellerby and Mr. Payne. Okay, everybody, before we start, I hadn't really thought about the notices from this perspective, but I think it would be helpful for staff if you all engage in a very short, it's a harmless exercise. If you choose not to comment or you say, Jocelyn, I just don't know, that's fine. Based on some of the comments we received recently, I thought we should ask this question since staff prepares its notices and publishes them on sheets of paper that are, of course, 8.5 by 11. Now, what I've done, Ms. Purvis, Producer Purvis, would you please display what's on the document camera? Is that too bright? Producer Purvis. The lights aren't on. Hold on. Too bright? All right, let me try this. See, I think I need the background. It's too bright. I did. Okay. So this is my question, everybody, and I will begin with our agenda and the entities that are listed, just for the sake of staff. You see how the piece of paper that I have here there's a green sheet of paper underneath, and of course we don't produce the notices, print them, the notices that are actually sent by either email or U.S. mail to customers. But I haven't did the best I could here unless I found a darker sheet of paper or a book, which I might. The white paper that I have here that's on top of my green sheet of paper, I'll lay the ruler on the paper so you can kind of see as a guide. So if you see where the number 7 stops here on the ruler, about 7 by 7. So that's really what the white sheet of paper that I cut out and then tried to denote on the paper that's the width, length, and width, the dimensions of the white sheet of paper. Okay. Yes. Oh, we can try that. Hold on. Okay. For this purpose, would you display the state seal while I... What do you think? Oh, you can't see it yet? I think Randy turned the lamp off.
That's the back light. The back light's probably worse.
I think that's better. There we go. I got it now.
Yeah, you want the back light.
Yeah.
That's when you can do it.
Okay, producer purpose, I'm ready. I think that's better, everybody. So, I'll start with Lockhart Power, if you don't mind, Ms. Fox and Mr. Turner. Do you know if your customer notices or your notices that you send to customers are typically smaller or larger than my 7 by 7 illustration here? 7 inches by 7 inches illustration here.
Typically, we use a 8.5 by 11 for most. I mean, we don't do a lot of bill inserts or anything like that, but when we do, it's just typically on just on a standard letter size piece of paper.
Okay, this is all voluntary. You do not have to answer, but I think it gives us perspective as we prepare as staff these notices. And, well, not just staff, the commission as a whole. Thank you so much, Ms. Fox and Mr. Turner. Attorney Richardson, do you happen to know?
Unfortunately, I do
No
not
problem.
know. Thank you.
No problem. Duke Energy Carolina, Mr. Attorney Trawick, do you happen to know?
Ms. Boyd, I know that our bill insert dimensions are 3.5 inches wide by 6.6 inches tall
Thank you so
for the
much.
companies. Thank you.
Attorney Huber, I'm not going to ask, of course, you anything, Attorney Hall. Mr. Ellaby or Mr. Payne, do you happen to know? Okay. Okay, this is just helpful for us. We appreciate everyone's, your transparency as relates to printing and publishing notices. And I think the more information that the commission has, of course, as it relates to its notices, the better decisions it can make. So I will move now to short summary of comments by Ms. Fox and Mr. Turner, please, with Lockhart Power.
Good morning, Jocelyn. We didn't really have a lot. We appreciate everybody working on the template, and I think the most recent one we saw was from Mr. Hall, the consumer advocate, incorporating notes, and we think it looks good. A couple of things we focused in our comments that we filed on the concept that we discussed last time about petitions to intervene and making sure that consumers who receive this notice understand that simply emailing or calling or whatever does not meet the legal requirements for filing a petition to intervene. I think Mr. Hall tried to incorporate that concept here. I would say I think it's still clearer in that bullet that says email communications at PSC. I think it should still say email a petition to intervene, because I think it still could be construed that, oh, I can file a petition to intervene by emailing. It has to be emailing a petition to intervene, and then he did incorporate the concept that we had in there that it has to comply with the commission's regulations, and it has to be accepted by the commission. So I think that's good. We did review also other parties' comments. Again, it's so important to limit these bill inserts to 2 pages. Of course, I guess that's easy for Lockhart to say. I did not realize that other companies may have a much smaller bill insert, and that makes it even more important to give the companies the flexibility, as I think Mr. Ellerby suggested, to do either a bill insert or a direct mailing as may be appropriate for the particular circumstances of the case. And also the flexibility to do separate mailings for the merits hearing and any public hearings that may be held. If that's necessary to separate those into 2 in order to keep it to 2 pages or 1 page front and back, we think the companies should have the flexibility to do that. And I think, Mr. Turner, anything you want to add to that? Did I cover everything?
I think you covered everything, Peg. I appreciate it.
Great. Thanks, David.
Ms. Fox.
That's all we've got, Jocelyn, unless
Okay.
you have any questions.
I do, just a quick question. I will have a follow-up question for everybody about the separate notices, but we'll wait for that. It won't take long. But I want to make sure I captured, I'm using Attorney Hall's draft that he and Mr. Terani, and I did read his comments where he said he incorporated your suggestion. But the one that you, we have a new document camera here, y'all. Everybody's gonna love it. Trust me. We no longer have an Elmo. I've been instructed, do not respond or something might happen. Do not call it an Elmo. So it's a document camera, and that's what I'm enjoying using this morning. I think you all will too. But Ms. Fox, what I've done is I have added, I think, in the notice that Mr. Hall provided, the petition to intervene information. I just want to confirm that with you. So Attorney do you want to be one? Okay. Producer Purvis, would you display what's on the document camera? Well, you really can't see it like I want you to. Okay. Perhaps that's better. Do you see where I'm about right here?
I can see that there's something on there, but I can't read it, Jocelyn.
Okay, I think she's working on using the Zoom.
Yeah, it's really bright though.
It is, okay.
Email, I see a petition to intervene right there. Yes, that insert.
Is what you were referring to? Okay.
Right.
All right. Thank you.
That's right. Oh, and we did have one other thing on the consumer advocate template, Jocelyn.
Okay.
There's on the why is this notice important?
Yes.
The second bullet that talks about the Public Service Commission watches over businesses, et cetera. I thought that we had agreed earlier to not try to give a simplistic explanation of what the PSC does, but to leave that out, because once you start trying to explain what the PSC does, I think you run the risk of either lengthening this notice by a whole lot or being overly simplistic. And so I think we decided not to address that bullet point, and that will help shorten these notices too.
Okay, you're not opposed, excuse me, to the language that reads the PSC has scheduled public hearings in this case and will decide what rates a utility can charge, just the first
Right.
sentence. So,
Yeah, I think that part is fine. But trying to, explain what the PSC does in one sentence, I think is problematic.
okay, so I will display it again. And in your reasoning, Ms. Fox, as you said, is the commission's duties are really diverse. And so trying to summarize its duties in one sentence is probably not the best
Right.
thing. Okay. Thank you so much. Unless you have something further, we will move on.
Yep, thank you.
Thank you.
Thank you.
Next on the agenda, Attorney Richardson, please, for Piedmont Natural Gas Company.
Thank you, Ms. Boyd, and the staff as well. Piedmont doesn't have any further comments at this time. We just really appreciate the opportunity to participate in the workshop and appreciate the hard work that all the staff and that has put into this effort. Thank you.
Well, we appreciate you being here regardless because, as I said, I had one question earlier, for example, just so that we're more aware of how the commission's notices are printed. And I do have one other, but it will be for everybody later on, once again, voluntary.
Oh, thank you again.
Voluntary. Okay.
We appreciate it.
You're welcome. Okay, next, Attorney Treywick.
Thanks again, Ms. Boyd. Just want to reiterate the company's appreciation for the commission taking the time to study this issue and make sure that customers get more readable and efficient notices out. The companies just have a few suggestions, some more global, some more discrete. I'll start with a couple of the discrete ones. So font size, of course, improves readability, but with that also comes cost. So for instance, in the notice that was provided, increasing the font size to 12 would lead to an 80% increase in cost to customers of putting that out. In the same vein, using color and highlighting, colored font and highlighting leads to an 18% increase in cost to customers. And so we would just submit that for the commission's consideration as we look into how to style these notices. We reiterate what Attorney Fox said earlier in mentioning that Attorney Ellerby said the same thing. We would prefer separate notices for one, the application and evidentiary hearing, and two, for public night hearings. The companies believe that this would help prevent customer confusion as to the nature of each of those hearings. Again, there are certain limitations on the number of bill inserts that can be distributed in a given month due to postal restrictions for bill mailers, the size of the bill insert, availability of bill insert slots, and then depending on what we do here, the length of the commission notice. So wanted to flag that for the commission.
What are those constraints? Can you give me an example?
They're primarily internal. If I can get back to the client, I'm happy to submit more explanation on that via written comment if you would prefer that, Ms. Boyd.
Yeah, I
Sure.
think the more information we have for the commission, I think they can, it can make better decisions. So even if they are internal to the extent the companies want to share.
Sure.
I think that would be helpful.
Sure, I will flag that. Thank you.
Okay.
And then also we recommend changing the more specific language of by U.S. mail via bill inserts to simply via mail. And that's again to provide some flexibility here to the companies, particularly when the time frame is more compressed in rate cases. And we believe this is consistent with and allowed by SC Code and Regs 103-817C3A. And last, this is a more discrete one. The full title of the docket or caption title should be used at the top of the rate case notice, and that would eliminate the need for the fifth bullet down there. So those are the company's comments on the rate case notice, and then I just have a couple minor ones on the newspaper notice. We recommend including contact information for the applicant, ORS, and DCA. And then also we felt like the statement of legal authority and jurisdiction for hearing section, and then the reference to particular sections of statutes and rules involved sections were a little duplicative. So to decrease the length of that, we recommend combining those into one.
Okay, give me a second, please, Attorney Treywick. I want to use our newspaper notice.
That would be the third and fourth sections that are substantive and not just the docket case and name and number.
Okay, yes, the docket, so combine the docket case number and case name.
No, I'm sorry. Combine the third and fourth ones at the bottom, statement of legal authority and jurisdiction for hearing, and then reference to particular sections of statutes and rules involved. The companies would recommend combining those.
Okay, and was that all on the newspaper notice as it relates?
That concludes our comments on the newspaper notice. And again, thank you for the commission taking the time to study these issues, and we appreciate the opportunity to be heard.
Okay, give me one other second, please, while I. Oh. I thought there was one other point that you made. I've marked on my draft newspaper notice what you mentioned, Attorney Trawick, about combining the statement of legal authority and the reference, but I don't know why I thought there was one other. Oh, the transmittal letter by U.S. mail via bill inserts. Yeah, that's in our transmittal letter. The
Right.
company wants the option. Full docket caption. Yes, I remember that. I think that's all right now. I think that's all right now.
All right.
Thank you. General Counsel Huber, would you please summarize your comments?
Thank you, Ms. Boyd. Yes, this is Chris Huber for ORS. And likewise, as other parties have stated, we appreciate the work of the commission to improve notices, and we appreciate the opportunity to file comments and to be here today to present those comments. We really had just one recommendation in the letter that we filed last week, and that was similar to one Mr. Trawick just had regarding the newspaper notices. We recommended that the contact information for the utility and the commission be included, as well as the contact information for the DCA and ORS was already on the template, but we recommended adding the contact information for the commission and the utility, similar to how the full mailing or bill insert notice template was set up. That's the only comment we had, Ms. Boyd. Thank you.
Okay. How's that producer purpose on the document camera? What is it? Can you see it? What I've placed? Okay.
Ms. Boyd, I cannot see anything, Ms. Boyd.
Oh, okay. She's not displayed it just yet. 1 second. I don't know why it's so Okay, everybody, I'm doing this until we figure out some more hold on a second. I'm just placing the document closer to the camera lens. There we go. So you can see where I've referenced, I would not enlarge it as much. Just back up a little bit. There we go. There we go. So DEC, Duke Energy Progress and Duke Energy Carolinas, you can see where I noted your comments. And then General Counsel Huber, you can see where I noted your comments at the bottom of the newspaper notice. I'm holding this. That's hence the reason for the movement. Okay? I just want to make sure everybody can see the notes that we're making. Thank you.
Ms. Boyd.
Okay, we'll move next to Attorney Hall, Roger Hall.
Good morning again. And Josh, I was gonna point out, that I do believe Mr. Trini is on as well.
Oh, is he? Good morning, Mr. Torini.
Good morning.
All right. Are y'all gonna tag team on this? Joint effort?
I'll follow Rob.
Okay.
So, yeah, that was gonna be my guess for you to say. So yeah, as we sent a letter after the last workshop, you had asked, for Mr. Trini and I to work together, and we did that, and, submitted the revisions that you've seen, and discussed here. Won't go over all the bullet points from our letter. I'll touch on a few, and then I'll try to follow up with maybe some of the things that have already been talked about this morning. So we did try to incorporate some of the comments from the last workshop. We revised some language and revised some formatting for consistency, flow, spacing, et cetera. We added some language from the additional April 5th revised template that the commission put out, and I will comment on a couple of those things here in a minute. I think most importantly, at least what I think is most important, is that we reformatted the information so that all the case information is on the first page and all the options for participation are on the second page.
Mm-hmm.
You know, I've heard what Duke said about a separate notice regarding the public hearings. I don't generally have a problem with that. I know at times, you know, the commission has been pushing to try to get those night hearings scheduled so that it can all be sent out at the same time. I know that may not be possible every time, in which case, you know, sending two would be fine. You know, there's been a lot of talk about costs, so I do question whether sending two notices is the most cost effective. So that's generally just a quick overview of where we were. If you don't mind, I was going to just go through a couple things that have already been talked about and just maybe go in sequential order from our notice of filing.
Sure. For someone who, you know, has not had the opportunity, and perhaps they're watching this event today and they hadn't read your comments, I think that would be helpful, Attorney Hall.
Okay. I can try to share I don't know if sharing my screen is helpful or not.
Can you share his screen?
Sure.
You're telling me you can.
Okay, let's try it. And just let me know if that needs to be bigger. It looks like maybe.
Bigger, y'all? Yeah, please enlarge it. I think that's awesome.
Okay. So I guess this is going off of memory, so I may not cover everything that we changed between the first and the second and how we incorporated it with what the commission had already put out. But we did put the full, I noticed you all put the full case name in it. So instead we moved that to the top here, so you've got the full case name. One suggestion I would have, and I didn't put this in the letter, is and this is very standard template, I guess, for a case name. But you notice it says list all the possible changes and it says and/or regulations. I mean, to me, it seems like we could determine what is actually being filed and requested instead of listing them all and saying and/or. I think if you recall, originally we just suggested it to say proposed change in rates because that's what we thought would be most important to consumers. But I understand including the entire case caption, but just a thought that maybe if there are no changes in regulations or classifications, they don't need to be listed as a little side note, something I just kind of thought about this morning. This next sentence, I'm trying to kind of mark it with my cursor here where it's highlighted. I realized that was not included in the last commission template, so it could be deleted. Though I do think maybe just saying that the Public Service Commission, basically deleting what I've highlighted and saying the Public Service Commission has scheduled public hearings in this case and will decide what rates the utility can charge. That might be important so we do understand what the role is. And obviously that might change if this is not for a rate case, but maybe something simpler, just an idea. I believe Mr. Treywick commented, his comment was directed towards the newspaper notice, but again, we added these code sections here to reflect what the commission had put out. And I think they could probably combine here as well. Going back to the separate notices part, I feel like the revised templates do a pretty good job of trying to explain the difference between the full hearing, or at least distinguishing that there's a full hearing and a public comment hearing. looking at it again this morning, perhaps this section right here could explain that it will be subsequent to or after the public hearing that's discussed on the second page. I put a comment, maybe that this is the full hearing will take place after the public comment hearing discussed on the next page or discussed on option B. I guess that would depend on if there's going to be 2 notices sent out or not. So again, so here you have the first page, it says all the case information, and at the bottom directing the reader to the next page. And so this is, I guess, what I have highlighted here under option B. So now we have the first option, option A, file a letter of protest. My letter noted, I believe other versions said something like filing public comments, or there was another statement there. It was my understanding that anything that's filed ahead of time is in the form of a letter of protest. If that's wrong, certainly if the commission accepts an email with general comments, then that should be added back to option A. But we did link here to the commission's information on how to file a letter of protest. And again, so moving to option B, try to indicate that these public hearings will happen before the PSC hears the case. It's got the highlighted part of it. It's bold and underlined to indicate that.
Attorney Hall, before you continue, on option B, I just hit. So when they say they hear the case too, what do you think about? See, I don't want to minimize for the public, those who aren't as familiar with the commission's processes, that the case also includes their testimony at the customer public hearing. So this just hit me as you were reading aloud. So under option B, where it reads, attend public hearings before the PSC hears the case. Here's the company's proposal, companies and others proposals. Would you object to, because I don't want, sometimes people, if they haven't testified at a customer public hearing before, and we've been asked that, how important, well, your testimony is a part of the record, it's a part of the transcript, it's a part of the decision making.
I would say 2 things our language that we've indicated here, we're not wedded to that. It could certainly be revised. I think we're just trying to give a general idea of what it could look like, but I will note, if I'll scroll down a little bit, that we did keep some of the language here. I think some of it talked about maybe being removed at one point, but under this option B, it does explain that you need to pre-register all testing, and that all testing will be given under oath. And that I think originally we had just said testimony becomes part of the case record. I believe somebody else had indicated at one point, or maybe it was in the commission's, there's that it was like unless a party objects. So I think we tried to address that here. But certainly, again, particular language isn't as important to us. We've talked about reading grade levels and trying to simplify things as much as possible. I think just with that in mind, again, we're not going to try to dictate exactly what the commission says.
Okay.
Justin, I will say on this part, I believe it was a little hard for me to read too, but I believe when you were talking to Ms. Fox that did you insert the petition to intervene in
Yes,
this
sir.
section?
I did. So
Yeah.
let me show you where, and Producer Purvis will show you. Hold on.
I think it needs to go in the next section because this is just for the public comment period.
Okay, Producer Purvis, I'm working on it.
Yeah, I see that. I can see it. Yeah.
Let me see.
So because that's option, petition to intervene is option C. So I believe that statement, which I have other comments on too, but should go under option C where it says the same thing.
This is a balancing act. Hold on a second. After, can you give me that book? That one. Producer Purvis, let me try this one. How's that, Attorney Hall?
I can see that.
You see where I have like under, no, the light's not on. You see it under deadline to pre-register 4 p.m. and then that's where we inserted the email a petition to intervene.
Right, what I'm saying is this is all under option B, which is for attending the public hearings. And so the option C is the filing a petition to intervene. So if you scroll down, if you look down under option C, it says something very similar. I believe that's
Okay, I
where-
see. So hold on, let's see. Jocelyn did this wrong. I did that wrong. I apologize. Attorney Fox and Mr.
What?
Turner, I apologize. I wrote your information in the wrong place. I apologize. Let me correct this right quick.
Yeah, sorry, Jocelyn, I couldn't see when you were showing me.
That's no problem.
Yeah, because it was so bright, but Mr. Hall is correct. It belongs under option C.
C. And then I guess email under the pre-registration. We can leave that alone. Okay, here it is. Here's the revised one. I think that's a little better, produce the purpose. So, Attorney Fox, Attorney Hall, do you see where I struck my mistake in option B and added it to the correct section?
I did. One thing I will point out why you're showing that, Jocelyn, is we added a sentence, and it may, again, I think maybe it could stand out more. We tried to address that by, see the line right above, where you wrote that in, it says, to intervene, you must file a petition to intervene by. You know, gives those two options. Again, I think there's any number of ways that it could be addressed. You could maybe delete the sentence we put and say, email a petition to intervene. But I think you should also say mail a petition to intervene under the second option. Either way, gain a little space back by removing the sentence that we added.
Okay, now tell me the beginning of the sentence that you added. So I do see where I need to add after mail a petition to intervene, but
if you look at the last sentence before you get to those two bullet points.
Yes, sir.
It starts with to intervene.
Yes.
You must file a petition to intervene by.
Yes.
That's how we tried to address it. Again, I think this suggestion is fine, but then you can delete to intervene, you must file a petition.
Yeah, because it would read, file a petition to intervene, and intervener becomes a party in the case. Interveners have the right to testify, cross-examine witnesses, and appeal.
I guess you could say to intervene, you must.
And then strike the rest. Hold on.
Yeah.
Producer purpose. Oh, hold on. I think you can kind of see the concept. Okay, Attorney Hall, you see where I struck the sentence? I left the colon at the end, and then we include the petition to intervene reference in the first and second bullets.
I think that would be fine.
Okay. Great.
And then just while you have it there.
Yes.
and Summarize the last couple of things from some changes we made. We kept, the part where you must, right below that, you must give a copy of the petition, your petition to all parties. And I believe there was Lockhart's comments again about meeting the requirements of commission regulations and approval from the commission.
Okay, for this purpose, would you let us refer to Attorney Hall's shared screen?
Oh, I stopped sharing it.
Oh, you did?
I can reshare it. If you like. It's I think you've got it on it, but I can reshare it.
Okay.
So, yeah, just here towards the bottom, with the two asterisks that saying that all the parties do need to get a copy and that it has to meet commission regulations and must be approved. So that, and I understand that it's not simply a matter of me mailing it or emailing it in. It has to meet certain requirements.
Okay, that makes sense. Thank you so much, Attorney Hall. Did Mr. Attorney Taraney have some follow-up comments?
I was going to add, the last thing I was going to add was that the one comment, I'll let him see if he has anything else to add, but and it's been mentioned already about color, and we are fine with there not being any color. I understand that does increase costs. I know Mr. Taraney commented that in this particular template that we used, the commission logo was still in blue.
So removing the logo from your perspective is not a problem?
And I didn't see, I'm gonna stop sharing this now. I had just one other kind of comment question, and maybe go back to Mr. Travick at some point, but I was wondering is it just their bill inserts that are 3.5 by 6 inches, or is the entire mailing? If the envelope today is already large enough to accommodate 8.5 by 11, that would be our preference. I mean, and I understand the font issue, but I've started realizing here recently, I've had pretty good vision my whole life, but as I'm getting older, it's getting tougher, and I can't even imagine trying to read 8-point fonts on a 3.5 by 6 inch card, particularly with this information.
Okay.
So I would just say, to the extent that it can be larger, I certainly think it probably should be. I again understand there's a cost issue, and maybe that's warrants further discussion, but we can come back to that. I'll let Mr. Tree.
Okay.
This one.
All right. Attorney Taraney?
Thank you, Ms. Boyd. First of all, I'd like to thank the consumer advocate for doing the heavy lifting on putting this notice together. We're delighted to work with him and be able to come to an agreement on a notice form. As for the Southwest Water Companies, because we're on a moving billing cycle, our bill inserts are mailed separately. So 8.5 by 11 doesn't cause us any particular problems. I would suggest, though, that it might be good for the clerk's office to retain some flexibility to work with companies on a case-by-case basis on these notices. It doesn't have to be a rigid format across the board. I mean, different cases may warrant different things. I had a couple of thoughts. From our perspective, I think one notice is better if the public hearings, but again, generally, I mean, it could be that in some cases, public hearings get scheduled later, but one notice means less cost. Avoiding color means less cost, and so we're in favor of that. And even the commission's logo, if it's printed in grayscale, that would be fine with us. One minor suggestion I would make regarding interventions, and I hate to be a stick in the mud, but it might be worth putting some language in there that says and I need to pull the notice that we proposed up. In option C, where it says file a petition to intervene, an intervener becomes a party to a case, interveners have a right to testify, cross-examine witnesses, and appeal the commission's decisions. I suggest it might be a good idea to put a phrase in there to the effect of, "it must follow the commission's rules of practice and procedure." Because, I mean, that sounds like, the way it's worded right now, I think maybe to an uninformed person, it sounds like you get all the benefits, but have none of the obligations. And I think we've seen over the years, some interveners kind of getting in and then realizing, whoa, this isn't what I signed up for. And it might be just worth adding that cautionary language. So I leave that for your consideration. Finally, it occurred to me that y'all were talking about explaining the role of testimony in the public hearings. And I looked at the sentence in the notice that we provided. It says testimony becomes part of the case record unless a party objects. I wonder if we're just trying to explain too much, and if it would just be worth deleting that, or just say testimony becomes part of the case. Unless a party objects implies that if a party objects, it's automatically going to be part of the case. I think we're just trying to maybe overdo the detail here. People generally understand that they can come to a public hearing, they give testimony under oath. It's not a futile act. I mean, it's being done for a reason. The commission is going to consider it. If parties have objections to it, then that naturally follows. I just wonder if that's just overkill, and if it might just be better to just delete that altogether and just say all testimony will be given under oath. That suggests something that's important.
Attorney Tarani, may I ask you about that? Do you have an issue with the wording testimony becomes a part of the case unless ordered by the commission? Because ultimately, even if someone objects, it's still,
I mean, yeah,
unless
I
directed by the commission.
I guess and again, I don't know if this matters too much to my clients, but just from a practical standpoint, I don't know that explains anything to anybody. I mean, it maybe you could just say it becomes part of the case. It's part of the case.
Okay, you're right.
Just because it's not admissible, you're participating in the case, and then somebody comes along and objects. I mean, if I try to introduce an exhibit into evidence and Roger objects to it and the commission sustains the objection, that's still part of the case. Ms. Wheat's writing it all down. The exhibit can be proffered.
Okay, I understand what you're saying. Even if the commission grants the motion to strike, it's still in the record, and somebody could proffer whatever if they want to appeal. So yeah, it is still okay. I see your point.
I'm just, yeah. In the one hand, under intervention, I'm trying to caution these people, but under public hearing, I'm really just trying to encourage them. I
understand your point. I had to think it all the way through. You're right, because someone could still be an appealable issue. It's still part. Okay, I'm with you.
And I really think that's all I have.
Okay. So let me show you what I've done to be fair to everybody. Okay, Attorney Tarani, hopefully you can see some of this. So I did strike the unless a party objects. And I did add and must, in the next option C, after an appeal, I'll strike the and there and add the and at the very end and must follow the commission's rules of practice and procedure. I think those were your comments.
Yes, ma'am.
Oh, and then I have this, if we're going to use the logo, grayscale down here at the bottom.
Yes, ma'am.
Okay, thank you.
Thank you.
All right. Attorney Ellerby, thank you for waiting patiently. If you and Mr. Payne are ready, we're ready.
Thank you. We will not go over things that have already been discussed with other parties
Okay.
very much. We're trying to, first of all, thanks for the efforts. Everybody is working hard and we appreciate. And I think there's been huge improvement already from this effort in the notices that, that are going to be going out. The thing I would like to emphasize, Mr. Payne has some specific information about mailing costs
Oh,
and
that'd be
things
awesome.
that will be helpful to you.
Okay.
Maybe more helpful than what I would have to say. But
Okay.
my experience has been, and I've dealt with you on these issues. We can save money by putting notices, by disseminating the notices as billing inserts, but only if the companies are given enough lead time. And the savings are substantial, particularly for the bigger companies. And therefore, the sooner that, and y'all, I think y'all have been working in this direction, Jocelyn, the sooner the commission can figure out, here are our night hearings that we're going to have for this case, and we're ready. We're going to go ahead and schedule them early, and then the notices can go out appropriately in bill inserts and save money.
Right.
And when we get added, when something like that gets added later, it has to be done by direct mail, which takes time itself and is substantially more expensive. So, we would just urge y'all to try to plan ahead and get ahead of the timing requirements on those things. But again, I want to compliment the efforts of everybody to try to simplify the messages, and I'll then call on Mr. Payne to give you all the information that he has on
Okay.
the mailing costs.
Thank you.
Is the light on? Does it need to be?
Oh, you won't need a light on that one, Mr. Payne. You want to, you're Mr. Payne, Mr. Zach Payne?
Yes, ma'am.
Okay, then we can't hear you.
All right.
Melissa, for the purpose, is it okay if I use a microphone and he can sit if it's better? Because I couldn't hear him when he just spoke. I think there's one on the floor down here that I can give him. They're not connected.
Okay. And I don't have a whole lot to add. I just
Want to make sure they can hear you, because if they can hear you, then the public can. That's the
Okay.
only reason why I was making that. Yes, sir.
All right.
Yes,
Sound
sir. You
good?
may proceed.
Okay. This relates to a question you had asked Mr. Traywick earlier, but
Yeah.
one additional cost that we may, if the size of a mailer goes over 1 ounce, we pick up additional postage costs.
Okay.
And just generally for the overall cost of notices going out, if it becomes a direct mailer, the cost of postage is really a big driver in the overall cost of the notice itself. So to that extent, if we do get to larger notices where, again, if we were to go over 1 ounce for us specifically, we would pay a higher postage amount on
Okay,
that.
Mr. Payne, so when you say an ounce, of course, is that based on one individual item first? That's what
The weight of the mail, whatever's going out in the notice, if that gets over 1 ounce, then we pay a higher postage rate than what, we would
Do you mean in
otherwise.
total?
In
I know I'm
total.
sounding silly, but okay. So
Yes.
for maybe 5,000 customers, if the total weight
If the weight of an individual,
individual notice is more than an ounce,
then our cost of postage goes up. So that's just,
increases. I'm with you.
so just, again, one point I thought of
Thank
when you
you.
had asked Mr. Traywick.
I think clerk's office on our mail machine, can't we, the weight is indicated on our mail machine, isn't it? You know? Okay, we have a mail machine here, so
Okay.
we'll be cognizant of that.
Okay. And that's all I had to offer.
Oh, okay. That's perfect. Thank you.
Thank you.
Okay. So everybody, I wanted to return just to the issue of cost, because if you recall, we talked about this before, and it was probably, I think we did in this docket, just the cost that the customer in the end incurs, basically in the rate that's charged for the commission's notices. And so I wanted to, Mr. Trewick, I can start with you, because I think Duke brought that to our attention, and also I appreciate you bringing to our attention the size mailer that you use. I think that definitely needs to be considered by the commission. But when you mentioned in your comments about the separate notices, and I'll start with you and then I'll ask everybody else. Let's say that we use Mr. Attorney Hall and Attorney Terani's suggested notice, proposed notice, which I have here, and we did not reference the customer public hearing in these two, because this document contains the customer public hearing and the public hearing, and the company's merits case. So I'm trying to see if it would result in. We issued a notice yesterday in a docket. It's a public document. It's a NAMPA proceeding. And it was just a notice of filing. And that notice that we issued was one page, and I know we used a size 12-point font. And it included a date to intervene. Of course, there was not a hearing date in that notice. And so what I'm trying to figure out, even if the commission did issue separate notices for a customer public hearing and then one for the merits hearing, would we just be dividing those costs instead of you paying them at one time, once, they'd be paid twice, but the customer wouldn't incur any additional costs?
That's a fair question, Ms. Boyd. We drilled down a lot of potential scenarios. That wasn't one of them, but I'm happy to go back to the client and look into it and let you know if there would be cost savings there.
Yeah, because I think that was a concern for once, I think it was another utility that brought that to the commission's attention about the cost at the last workshop we had regarding color and if the notice was more than 2 pages. And so, of course, that's in the forefront of my mind. Did Duke Energy Carolinas or Duke Energy Progress have any conversations with customers about the confusion of the notice with both events on it?
I am happy to check on that as well.
Please.
I'm not specifically directly aware of those conversations.
Okay. And so that was really that's my main question. I know the agency's seen filings before about the cost it incurs, and of course, those costs are passed along to customers about if the commission does not provide the notice in sufficient time for you to include it in your bill inserts. And of course, we have papers on our wall in the back. We know, for example, your company needs 55 days, Dominion needs 45 days. I think Mr. Terani's company said 45 days, so we're very well aware. Anybody who's told us that, we're aware of that. And I think we've been doing a better job about making sure that we give you sufficient time in the transmittal letter so that you can include it in the information in the customer's bill insert. But any other factors that you think might mitigate a cost increase if the commission were to issue 2 notices, I think would be helpful for the commission. Does that make sense?
Sure,
Okay.
sure, of course. And if I could
Yes,
quickly follow
please.
up on a question earlier,
Please.
I had the paper in my hand with the answer and didn't realize it. So
Okay.
our comments filed on May 18th of 2021 went through all the specific limitations that we have internally at the companies that could pose limitations on bill inserts. It's a 2.5 page letter that Katie Brown filed on behalf of the Duke companies. And it goes over the 55-day necessity.
Okay.
Kind of how many panels of an insert we could go to before it would have to go to a more costly direct mailer and things of that nature. As well as issues with when it occurs in the billing cycle and timing concerns and things like that.
Give me a second. I can find that letter. so I do see where, Mr. Attorney Traywick, the 55 days to prepare, which staff is aware of.
Right.
Bill inserts must be provided to the printer by the 6th, because that's just, I think that's justification for the 55 days.
Right.
Okay, and I think the next paragraph is related to the 55 days too. On the second page, how many bill inserts can be distributed in any given month?
Right.
And so the the sentence in the second full paragraph reads, at this time, both DEC and DEP each have 4 bill insert slots available to them each month. These slots are utility specific and are therefore shared across the Carolinas. The company's ability to furnish notices to customers via bill insert is contingent upon the length and size of the notice issued by the clerk's office. The largest bill insert the companies can send to customers is an 8-panel insert. If the notice is too lengthy to conform with the requirements for bill insert formatting, the companies would instead need to provide the notice to customers via an alternative method of communication. Okay, so I guess it would be helpful for me are the 4 bill insert slots the size that you mentioned, the total size in your letter?
Those are the dimensions.
Oh yeah, 3.5 wide
Right.
by 6 inches tall.
And the number of panels depends on how much information we're putting on there and the size of the font.
Yeah, so let me, I'm a little slow right now. So the 4 bill insert slots are the width of those slots is the total width, the 3.5 wide by 6 by 6 tall?
That's my understanding. Yes.
And you're limited to an 8-panel insert.
Yes.
So double that. Total 7 by almost 13, I guess, a little over 13. Because you're limited, if 4 bill inserts, the total dimension would be 3.5 inches wide by 6.6 inches tall, and you're limited to an 8-panel insert. All I'm doing is doubling the 3.5 inches by the 6.6. You think I'm off on that? So it'd be a total of 7 inches wide and a little over 13 inches tall.
Right, which is larger than the, I think, 8.5 by 11 that the commission was using as its template.
A little smaller. Well, it's a little,
Here
we're
there.
using 8.5 by 11. You're using 7 by 13, a little over 13. We just shifted where the room is, right? Kind of a little bit, got an extra inch tall on yours and 1.5 inches shorter on mine. 8.5 by 11 versus 7 by 13.2. You understand my point?
Yes.
Do you know if your bill insert, so I would still be and that's on one side probably, right?
Right.
Yeah. Okay. Clerk's office in the back, do you understand? We were working group in here today, sorry. What are you saying? So basically, we normally provide information on the front, for example, and the back, right? Or 2 pages. And their dimensions would be a little bit shorter than this, and a little bit taller than this. What's that? Let me see what size font you all use. I apologize for taking your time,
I think it's
but I
typically,
appreciate your patience.
I think it's typically 8-point font, Ms. Boyd.
Oh, 8-point font?
Yes.
And that's because of your contract, your company's contract with your printer, basically? Or is that for your, is that your internal, like, for example, here, we no longer have printing services we used 2 years ago. Meaning we would print testimony and bind it, all that's gone. So I understand the internal printing services. If you all are printing this internally, these are your constraints maybe?
Right, so once the proof of is finalized, it goes to a printer located in Florida.
Oh.
Right.
Oh. But based on your contract right now, I guess I'm asking the same question as your company's constraints. I mean, you could have a long-term contract with them. Those are the constraints, meaning this is the cost for producing the notice Duke and Duke with these dimensions, a maximum of 8 slots. This is what it will cost. This is what I'm trying to say.
Across the Carolinas.
Yes, sir, I understand.
Thank you.
Because when I say constraints, I'm saying that I'm assuming that your company has a contract. You don't have to answer that, and that these are the constraints based on that you have to, based on the terms of printing it on with the notice with these dimensions. Here's the cost. We'll produce the notice for you. Okay. I appreciate your praises. I know that was not
Thank you.
fluent, but I think it informs us here.
Thank you. Happy
Thank
to
you.
answer any other questions.
Okay. Thank you. Thank you, Afton. Attorney Fox and Mr. Turner, do you have any comments regarding the cost as it relates to separate mailings or one mailing? The cost that and how the publication or printing of the notices and how that might impact your customer? Whether one notice is printed with both the customer public hearing date and the merits hearing versus two, which includes two separate events.
Yeah, I'll let David address that, Jocelyn.
Yes, ma'am. As far as obviously, it would depend on whether again with the timing, just like we talked about with some of the other utilities, as far as if we could get even if it's one insert or two, whether it can be put in as a bill insert or if it ends up being a separate mailing. If it's a bill insert, our costs are going to be relatively minimal. If it has to be a separate mailing, for us it'd be some significant costs, but that's all relative, based on our size compared to everybody else that's in this discussion. So, a couple $1,000 for us is a big deal, which is a drop in the bucket for most everybody else. So, but that's kind of the range that we're looking at for those costs if it has to be a separate mail out.
Okay, so you could incur additional costs for a separate mailing.
Yes, ma'am.
Okay, thank you so much.
Mm-hmm.
Attorney Richardson, do you have any thoughts as it relates to the cost that your company might incur if one notice is issued versus two?
At this time, I don't have any thoughts, but
Okay.
happy to check with the client and just come back to the commission on that issue.
If you can, that would be helpful for us, please. Thank you so much.
Thank you.
And Attorney Trewick, appreciate you again. You were next. The only other, Miss Attorney Ellerby, did you? Well, your client did provide information, and you have some more information.
Well, I think it's in the letter that we
Okay.
sent in on the 22nd, have some estimates of insert costs versus direct mail and
Yes.
color and the various. I think that's the information we have on
Okay,
that.
thank you. And I think we have blue granite listed on our wall too as needing 45 or 55 days do we have on the wall? 45, does that sound right? Okay, so we're aware of that. Okay, and then Attorney Tarini, I think that, yes, you spoke earlier about your client's position. One notice is better, one notice equals less cost, and to avoid colors. I think we've handled that.
Right, but we do understand there may be the need for flexibility.
Yeah, okay, great. And then Attorney Hall, you provided your position, your preference, your agency's preference for a single notice if possible. And then General Counsel Huber, do you have any thoughts as it relates to the publication of one notice, which includes the customer public hearing, or just the hearing that does not include pre-file testimony versus two separate notices?
Thank you, Ms. Boyd. I would say, I mean, whenever, to the extent cost can be minimized, that's best. So whichever option minimizes cost, I think would be the better option.
Thank you. Okay, well, everybody knows right now the commission's transmittal letter just basically provides instructions. We attach the notice to be published, and it just states there's a timeline for publishing the notice or providing the notice to customers. We have internally started producing notices to you all that are size 12-point font. And I know within the last month that have been no more than 2 pages. I know that for a fact. Our regulations currently don't indicate what size font must be used in notices, nor do our regulations indicate the size paper upon which the notice must be provided to customers. So we appreciate everybody's, hey, Commissioner Powers. Your responses to our notice for today's workshop and our prior workshop. And I hope that you all will see continuous improvement on our behalf as staff in the notices that we issue, not only continuous improvement, but consistent continuous improvement. I think that's very important. And I know our team is very aware of the concerns regarding how long the notices are, the size font that we use, and also providing plenty of lead time based on what you all have told us about the length of time that would help so that you can include notices in your bill inserts. We are aware of that. Does anyone have any other comments before we leave? Ms. Fox or Mr. Turner?
No further comments, Jocelyn. Thanks for the opportunity to participate.
Thank you, and thank you both for being present and participating today. Attorney Richardson?
No further comments, and Piedmont appreciates the opportunity to participate. Thank you.
Yes, sir. Thank you for being here, and thank you for your comments. Attorney Treywick?
Nothing further from DEC or DEP, and thanks again for the opportunity to participate today.
We really appreciate your comments too, and thank you for being here. General Counsel Huber?
Thank you. Nothing further from ORS, and likewise, thank you for the opportunity to be here and provide feedback. Thank you.
Yes, sir. Deputy Consumer Advocate Roger Hall?
No further comments. Again, appreciate all the hard work over there. Thank you.
Yes. Attorney Tarini?
All good and always a pleasure.
No problem. Thank you too for being here. And then finally, Attorney Ellaby or Mr. Payne?
Nothing further from us, and thank you all for your efforts.
Yes, sir. Thank you. Everybody have a safe weekend. We'll see you next time.